ladies, my lord, good afternoon. Just one housekeeping matter before I continue on the ambit of the core immunity, and that is, my lord, Justice Mayles, you gave me some time to take instructions on the request for arbitration and the arbitration award. I don't have instructions to waive confidentiality in those documents, so I think that housekeeping matter goes no further. And so I propose to continue my submissions on the ambit of the core immunity. So I want to move on to Singh now, which is at tab 18 of the authorities bundle. And or page 377 if you're electronic. And that was a constructive dismissal claim with a last straw act that the employer put the employee under pressure to make a witness statement containing false allegations. So this was yet another case in Lord Devlin's third category of case as to whether it was necessary to extend the immunity to matters outside of the proceedings to prevent the core immunity from being outflanked. And the court held it wasn't necessary to extend the immunity. We've got at paragraph 16, this is on page 382, at H, a summary of the complaint made, indicate the nature of the complaints. After a lengthy review of the authorities, we fast forwards to paragraph 66 on page 394. Lord Justice Lewison summarises this part of the case, and we've seen already Mr. Pollack referred you to 66 Roman numeral 1. What hasn't been referred to in either of the skeleton arguments or the oral submissions is Roman numeral 2, which is the core immunity also comprises statements of case and other documents placed before the court. So we submit it's crystal clear as at the time of Singh that the core immunity is considered to apply to the initiating documents of the proceedings. And on the facts of Singh,
do you disagree with Lord Justice Lewison's statement as to what the core immunity is in paragraph 21?
We say that the basic rule applies to anything done in addition to what is said by the parties, the advocates, or the judge, and that we get.
Defamation can be brought against a witness for anything he says in evidence or does.
Well, we submit that so the anything done aspect is contained in Dawkins and Lord Rokeby, but we say it's not confined to claims for defamation because we get that from Heath. I was planning to take you to Heath shortly.
The thing is that there's nothing in this judgment in Singh that brings it outside the ambit of claims for defamation, is there? The whole of Lord Justice Lewison's analysis, all of the cases that he relates to, and the basic rule that he describes are about immunity from actions in defamation.
Well, what we'll say, and I'll take you to this in due course, is that Lord Justice Laws in P in the Court of Appeal had the benefit of considering both Heath and Singh, and he didn't consider that there was anything in Heath which is authority for the proposition that the immunity applies not just to actions in defamation, but any type of claim.
I appreciate that you may be wanting to make submissions about Heath. We haven't got to Heath yet.
Precisely.
I am asking you about Singh. Do you accept that Singh is simply about defamation?
I don't accept that Singh is about defamation.
In which case, would you like to please show me the passage in Singh in which Lord Justice Lewison addresses matters other than defamation claims?
Sorry, my lady, I think we might be talking at cross purposes. Singh's obviously in the third category of Lincoln, an extension case. He is there referring to defamation. I don't have any other passages that show otherwise in Singh, but my submission is that you have to follow the later case of P in the Court of Appeal, which does consider both Heath and Singh and that part of the reasoning of law justice laws wasn't disturbed on appeal by the Supreme Court. But I will take you to that in a moment. But that is my position on Singh. Hope that's helpful. I want to move back to the application of Singh to the facts, and at paragraph 70 on page 394. There, because the claimant's claim is not based on anything that Mrs. Heath might or might not say to the Employment Tribunal, she's not yet given her evidence. It is based on what went on outside the tribunal, and in particular the means by which the council procured Mrs. Heath to give the statement. So the claim there wasn't based on anything the claimant might said or might say or might not say in the tribunal. It was based on what went on outside the tribunal. Those facts are very different to the instant case.
I would have thought that if counsel was aware that the statement had been given under pressure, that might well have been something that he would have wanted or she would have wanted to cross-examine about when the witness gave the evidence.
But the reasoning there that it went on outside the tribunal and therefore was outside of the proceedings themselves, we say is apposite, because here the detriment is not just the decision to bring the arbitration, and we'll look at the pleaded case in a moment. The pleaded case is squarely the commencement of the arbitration, and so one isn't looking at some anterior act or decision on the part of the respondent as to whether or not it wants to bring the arbitration. One is looking squarely at the commencement of the arbitration, the initiation of the proceedings, and so we say that Singh is distinguishable on that basis. But in any event, it is clear from 66.2 that a request for arbitration statement of case would fall within the ambit of the core immunity, because this would be a statement of case or other documents placed before the court, or the arbitral body.
Is that right? I mean, might there not be a distinction between the act of initiating the proceedings and the contents of the document by which the proceedings are initiated?
We submit that the two are inextricably linked, because you don't do one without the other. The submission of the initiating document commences the proceedings, and that is only done with the content of the document itself. They are cumulative and connected. This is in the words of the majority in Heath that considered that as a possible test to the approach of the immunity, that one has to identify whether there's a freestanding act outside of the proceedings. There is not if there is a connected and cumulative complaint about matters inside of the proceedings. And our position is that here, because the pleaded case is not about the decision, a prior decision to bring the arbitration, but about the commencement of the arbitration itself, it's inextricable from the sending and the content of the founding documents of the arbitration in our submission.
I don't know that you can necessarily equate a request for arbitration in an ICC arbitration with a statement of case in court. It's a little while since I've been familiar with requests for arbitration, but my recollection is that they deal with things like who the parties are, who you want to nominate as an arbitrator, where the seat should be, that sort of thing, rather than setting out a fully explained statement of the case you want to advance, which usually, I think, comes later.
It might be more analogous, my lord, to the claim form, because the claim form there has identification of the parties, the destination of the form, and then a summary of the complaint itself, because you wouldn't be able to submit a request for arbitration without, in brief terms, explaining what the subject matter of the request is about.
It would have to identify the dispute.
And we submit then that the claim form is part of a statement of case. It's in the CPR that is the position, and so then by analogy the request for arbitration is a statement of case in the arbitration, or part of the statements of case that are placed before the arbitral body. And so we say that passage at 66.2 lends weight to our submission. I want to move away from Singh now to Daniels, the Chief Constable of South Wales Police in Daniels. And this was a different type of case completely to the others, because there the trial judge had held there was a general immunity for the prosecutor. That was overturned on appeal, and there was a remission decision to the trial judge to consider contested amendments as to whether or not they fell within the ambit of the immunity. And so it's not quite a third category of Lincoln and Daniels, but rather a case that is perhaps in its own category. But there's one passage that I want to take you to, which is at 410 of the authorities, in paragraph 40 of the decision. And Lord Justice Lloyd Jones, as he then was, refers to one part of a passage in Heath by Lord Justice Auld, who rejected the submission that the absolute immunity attaches only to defamatory statements. And it says, in doing so, he said, it attaches to anything said or done by anybody in the course of the proceedings. And then we have what follows is a discussion of the meaning of anything done in the proceedings. And we have three conclusions to draw from paragraph 40 in my submission. One is that Lord Justice Lloyd Jones says there that the immunity in Heath, the description is too broad. Two, the immunity is essentially a witness immunity concerned with the giving of evidence and the making of statements in judicial proceedings. And then he goes on to say the inclusion of the words or done in the references to anything said or done is not, to my mind, intended to extend the immunity to conduct unconnected with the giving of evidence or the making of statements. And my lords, there are 2 points to note in our submission from paragraph 40. One is there is no express acknowledgement here that Darker was a case dealing with witness immunity only, and not all aspects of judicial proceedings immunity generally, including parties' immunity. So the proposition there needs to be seen in that light in our submission. But even taking that test at face value, that anything done is not conduct unconnected with the giving of evidence or the making of statements, we say in our submission that that applies to the contents and submission of the request for arbitration and the statements of case, because they're plainly connected both to the giving of evidence and the making of statements. And if I can make 2 submissions on that, firstly, the initiating documents are the means by which the party initiating the proceedings expresses their complaint in the proceedings. The request for arbitration outlines the complaint that's about to be made. The arbitration notice, I think that's the analogue to particulars of claim, would set out in further detail what the particulars of that complaint are. And they form the blueprint or the parameters for the evidence to be given in the proceedings, because the evidence is the means to make good the fundamental points in the claim, in the complaint that gives rise to the proceedings, and in the initiating documents. And as we know from doing cases in any type of proceedings, the evidence will always be referencing back to the claim, to the founding complaint that initiates the proceedings. That fixes the issues by which the evidence is to be directed at. So our submission is that applying this test, that test plainly applies to the submission and the contents of the initiating documents in the arbitration.
Well, it might if the claim were for defamation.
Well, my lady, I will address you on that point in more detail very shortly when we come to look at Heath, Lake and P, because they have to be looked at together.
First thing is that this has nothing to do with what you described as party immunity, because it's not dealing with a concept of party immunity, is it?
My lady, we accept that, and we accept that.
Secondly, it relates to defamation.
I'm not sure that the
Possibly it goes further and deals with negligence, but that because there's reference to the carve out in relation to professional negligence in all and Simons. But the whole thing is really directed towards protecting the witness or freedom of expression in the context of litigation or adversarial process.
My lady, we will be absolutely frank about this. You're right that Daniels is a case about witness immunity, and that the statements need to be viewed in that context, as I submitted before lunch, as Lord Clive made clear in Darker. But we say that even allowing for that context, we say there is support to be derived in our proposition from paragraph 40. The authorities that I took you to earlier this morning, I don't intend to go back on ground that I've already traversed, is to the effect that the same immunity that applies to witnesses applies to parties. We saw that statement of the various opinions in Darker. We saw that statement in the Dawkins and Lord Rokeby. And on the defamation point, I'll come on to that.
Sorry to interrupt, Mr. Kemp. Surely those references to witnesses in context must be understood as, references to parties in context must be understood as references to the parties when they give evidence in support of their case, mustn't they?
Well, my lady, we don't agree with that analysis. It's a reference to parties in respect of their participation in the judicial proceedings, which may include that, but it also encompasses the initiation of the founding documents of the claim, because that can only be done by the party.
But you can't bring a cause of action against somebody. There is no recognised civil law taught for bringing proceedings against somebody in good faith. There is a tort of malicious prosecution, and there are various other allied torts to that, which all stem from abusive process in the court. But subject to that, there is no recognised basis on which you can say you issued a statement of claim against me, therefore, at common law, I'm responsible. What there is, however, is a statutory basis to claim detriment if you're a whistleblower.
My lady, we will look at some of the malicious prosecution cases relied upon by my learned friend, and needless to say, they are distinguishable because abusive process inheres in the cause of action concerned in those cases, whereas in the case of whistleblowing detriment, abusive process isn't an ingredient of the cause of action. But what we do submit is that Heath, that part of Heath that applies the immunity to claims under the Equality Act was left undisturbed when it by Lake, which is a case that was a whistleblowing case under the Employment Rights Act, by Lord Justice Laws when he considered those authorities in P and the Commissioner. And so I do want to take you through all of that to come full circle, as it were, to our submission that parties' immunity doesn't just apply to defamation, it applies to any type of claim, including a claim under the Employment Rights Act.
Right, shall we go to Heath, or do you want anything more from Daniels?
I've left Daniels now. I do want to look at XGY, if I may, which is an authority that I alluded to in the opening of my submissions, and that's right at the back of the second authorities bundle. And it's in tab 39.
Yes.
And this is the hot off the press, 8th of October judgment handown, and it's an advocate's immunity case. The principles do need to be understood within that context. See my earlier health warning point about viewing the authorities, but there are a few propositions which we submit will be relevant to the issues in the appeal, and if I can take you through those. Page page 1012, paragraph 8. What we have there at that paragraph is a restatement of the immunity as described by Lord Hutton and Darker, and we take from
I'm
that.
so sorry to interrupt, Mr. Kemp. Should we just start with finding out what the claim is about?
Oh.
We just go with that from paragraph 3.
Yes, I'm so sorry. Paragraph 3 are the facts. This is an advocate's immunity case, as I submitted earlier.
Yeah, but we want to know the context in which the arguments arise, don't we?
Of course, and this was a claim in negligence and breach of the Human Rights Act against the defendants in that case, arising from.
Advocate inadvertently, in the course of a bail application, revealed the protected party's then address.
That's right, yes.
It was confidential information. Judge struck the claim out on the basis that there was an immunity for whatever was said and done by advocates in court, and the judge allowed the appeal.
And that's right. The judge allowed the appeal, and then the Court of Appeal overturns the decision of Mr. Justice Ritchie in this decision. So if I can go to paragraph 8, there is a description there of the core immunity, where it says it is necessary for the administration of justice for certain participants in the administration of justice, advocates, parties, witnesses, judges and jurors, to be immune from suit, i.e. that legal claims against them arising from almost anything done or omitted to be done in the course of conducting a case in court are barred. And so we just take from that there's an acknowledgement there that the core immunity covers a party who has immunity from suit arising from almost anything done in the course of conducting a case in court. That's within the scope of the principles set out by Lord Hutton in Darker. In paragraph 9, where it says the core immunity is limited to actions in which the alleged statement constitutes the cause of action, relies on Taylor and Director of the Serious Fraud Office. We just note this, and I don't think there's a need to go to Taylor. It is in the First Authorities bundle, tab 12, but Taylor was a case in the third category of Lincoln. It was witness immunity being extended to certain out-of-court statements for the purposes of a criminal investigation that might lead to a prosecution, and the out-of-court statements formed the basis of the cause of action for defamation. And we submit that by analogy, when one is considering a case in the second category of Lincoln, the core immunity also covers actions in which the alleged thing done in the course of the proceedings constitutes the cause of action. I don't understand that.
Get that from?
Well, we submit that this is a submission that we make by analogy with the proposition that's set out in paragraph 9.
Well, isn't it directly contradicted by the proposition in paragraph 9? If paragraph 9 says it's limited to something, you can't say by analogy it's extended to something else.
What we submit is that the proper context for that proposition in Taylor is that the court was there considering a witness immunity case, not a case within the second category of Lincoln and Daniels, and that context does have to be borne in mind when construing the judicial statement that's made in Taylor and Director of the Serious Fraud Office.
It may well be that the Court of Appeal in this case were wrong to say it was limited, because they didn't understand Taylor, but that's not what they've said. They said it's limited. On the face of it, we're bound to accept that it's limited.
Well, they quoted from Taylor itself, where it says is limited to actions in which the alleged statement constitutes the cause of action. But we just submit that the proper context for that principle in Taylor is, of course, that that case was concerning witness immunity. There are some other.
But also, it's causes of action based on a statement.
Yes, with things done or spoken in court, however ingeniously framed, is put in paragraph 10.
Yes, the paragraph 10 refers to the early cases concerning actions for defamation, but it goes on to say, in order to prevent the immunity from being circumvented or outflanked, however, for many years the immunity has been held to apply whatever claims made against the advocate or witness for things done or spoken in court, and however ingeniously such a claim is framed. So we submit that it doesn't just apply to actions for defamation, it applies to anything done in the course of the proceedings by a party to the proceedings who is one of the participants in the proceedings.
But it doesn't talk about the proceedings, it talks about what's done in court.
Yes, we submit that submitting a request for arbitration and statements of case in an arbitration is something done in court, because
it's done remotely. You post or email your request for arbitration to the seat of arbitration in Singapore. How's that done in court?
well, because it's submitted to the courts, to the arbitral body, and it would then be referred to in court as the basis of the complaint before the arbitral body, including further particulars of that complaint in an arbitration notice.
But we're not concerned with what happens down the line. We're simply concerned with the initiation of the proceedings in the first place.
Well, of course, we're concerned with the initiation of the proceedings, but the relevance is what would the initiation of the proceedings entail? The initiation of the proceedings would entail submission of the founding documents to the arbitral body, to the court. And so we submit that we are within the second category of Lincoln and Daniels. Can I move on from this part of XGY and move on to paragraph 65, Roman numeral 1, which is on 1024, and this follows a careful consideration of Taylor, Darker and Hall, and another case called CLG, and we get at paragraph 65, it follows this in our judgment. Applications of the core immunity and its established extensions do not need to be justified on a case-by-case basis. And we say that is important in this case, that this proposition is important to achieve certainty for litigants as to what's in and what's out. That when one is looking at the application of the core immunity, it's a binary issue. Either the cause of action is in or it's out. There's no balancing or weighing up of policy considerations at the stage of whether the core immunity applies. I think that was referred to in this case as the approach of justificationism, which was had been adopted by Mr. Justice Ritchie and overturned by this decision. We also get at Roman numeral 2, the core immunity is not limited to evidential matters, and we submit that supports our case. It's far wider in scope, and then it says the core immunity attaches to statements said or written made in court. And we say that the request for arbitration and the related statements of case in the arbitration are statements made in court. They're made to the arbitral body. We accept that the source of the proposition into are cases concerning witness immunity, Darker and Taylor, which we see analysed earlier on at 64. But there's nothing there that doubts the proposition that the core immunity attaches to the contents and the submission by the parties of the initiating documents in the case. That was just simply not an issue for decision in XGY. But we say that the articulation of the ambit of the core immunity in XGY does provide some support to our case.
Going back to the rationale for this immunity, which we can see summarised at paragraphs 12 to 14, conveniently, what they seem to be saying is that you have a rule of immunity in order to protect witnesses and advocates and so forth, who are, in order to protect witnesses and advocates who are, as it were, bona fide, you have a rule which protects even the bad actors, because that's, if you didn't have such a rule, then all the good people would find themselves getting sued unmeritoriously. But if you apply that to our circumstances, if you have immunity to protect employers who are clamping down on genuine whistleblowers and depriving them of a remedy, isn't that pretty clearly contrary to the parliamentary intention that whistleblowers should be protected? After all, if you are liable to be sued for making a disclosure, it's a bit hard to call it a protected disclosure. You're not protected at all.
My Lord, we submit this. We submit that the same reasoning that applies in terms of the public policy ground for the core immunity would also apply to a party in the proceedings in terms of their decision to initiate the proceedings, and the rule has to be wide in order to protect legitimate employers and the illegitimate employers as well. But
that's all a matter for the tribunal to sort out. When it's heard the evidence, it can then decide whether the alleged detriment was made on the ground that the person made objective disclosure.
Well, my lady, we'll move on to this shortly, but we submit that does trespass into the documents of the arbitration, the request for arbitration and the statements of case, that a tribunal looking at the reason why will have to look at those documents to make a decision as to whether it was the fact of the disclosure or the manner.
Absolutely not. No, the question is...
You won't let it.
You won't let it. But the question for the tribunal will be, having heard the evidence of whichever witnesses are called to explain why the arbitration was initiated, will be to decide whether part of the reason why they did it was on the ground of protected disclosure. That's pure and simply it. They won't have to look at any of the underlying documents.
But, well, we will make submissions otherwise. You've seen our skeleton argument, we make submissions otherwise. But can I just try and address your, my Lord Justice Bales's point? We submit that there are sort of two ways of looking at this. One has to look at the core immunity first, does it apply or not? And one has to look at the public policy grounding of the immunity as it would apply to a party. And we submit there that the width of the rule should be as wide as it applies to witnesses in order to protect parties in the proceedings, because we know from the case law that the immunity of witnesses is extended to parties, and the reasoning we submit for that applying to parties is a fortiori, that they should not feel inhibited from bringing a claim or expressing themselves as to the complaint that's the subject matter of the claim, for fear of vexation of actions, possibly multi-jurisdictionally, further down the line in other courts.
But let me try and put it another way. If you are liable to be sued for making a disclosure, in what sense is the disclosure that you've made protected?
Well, my Lord, I'm sorry, I'm trying to answer your question, but I think if one accepts that the core immunity applies, we say then there is no dilution and modification in the Employment Rights Act of that. So the issue of parliamentary intention is not relevant to the analysis, and we will look at the relevant analysis in XGY on that in a moment. But of course, if we're wrong on that and the detriment isn't within the ambit of the core immunity, the case goes to trial, and of course the matter for trial will be for the trial tribunal to consider whether or not the disclosures were protected under the Act. There's nothing, we're not doing anything that stops that consideration.
Well, you are if you succeed in this argument.
No, we're not, because the claimant still has a claim for protected disclosure detriment.
Well,
it's
he
just that it's
happens
that-
to have
but
got
not
two
for this
others,
detriment.
not for this detriment. He's got no claim for this detriment, if you're right.
yes, that's
So
right.
you're effectively driving a coach and horses through the Act, because if, as my Lord says, the bringing of suit against a whistleblower is conceptually a detriment. At the moment, I can't see any reason why it isn't a detriment, and that applies to arbitration equally. Then there's no protection for him against that detriment if you can turn around and say, I'm immune from suit for that. Sorry, free pass.
Well, can I address you on that, because I think it's convenient now to look at what XGY says about the intersection between the core immunity and statute, and paragraph 75 of the judgment 1026, and the relevant paragraphs there are through to 78.
Sorry, 75, 78.
75 to 78.
Thank you.
We see there that the issue there that the Lady Chief Justice is dealing with is whether the Human Rights Act is in some way in a different position to any other statute, such that claims pursuant to its provisions are not affected by the immunity. We do not consider that it is. And then at 77, we get the reasoning there that one has to see whether expressly or by necessary implication, that there is demonstrated an intention on the part of Parliament to dilute or modify the core common law immunity. And we submit that this reasoning is a fortiori with a claim under the Employment Rights Act, that the Employment Rights Act is in no sense different to any other statute, and there is nothing in the wording of the Employment Rights Act which expressly or by necessary implication demonstrates any intention to dilute or modify the core common law immunity.
Well, necessary implication. If the effect of what you're arguing is that somebody doesn't get protection for a protected disclosure, and it's the intention of Parliament that there should be protection for a protected disclosure, then I would have thought it follows as night follows day by necessary implication that Parliament says if there would otherwise be a core immunity, we're making inroads into it.
Well, we had precisely the same situation occurred in Heath, because those were claims under what was then the Sex Discrimination Act. And I'm going to take you to the reasoning in Heath, which is that the immunity applies to those claims. And that reasoning has not been disturbed by any subsequent cases. And so that
wasn't anything about the Heath was nothing to do with the initiation proceedings. It was to do with the constitution of the tribunal.
Well, the proposition that the immunity applies not just to defamation claims, but to any type of claim, including sex discrimination claims, that obviously Parliament has intended protection from sex discrimination, but there's nothing within that statute that expresses any intention expressly or by necessary implication of a dilution or modification of the core immunity. And we say that this passage in XGY, combined with the passage I'm about to take you to in Heath, it disposes of the argument on statutory interpretation that my learned friend relies upon, because section 43J and the words any detriment do not satisfy the high threshold for a necessary implication. So I think it might be convenient now to take the Heath, Lake and P points, as it were, and can I go then to Heath, which can be found at tab 14, so in the first authorities bundle. And it's paragraph 17 and 19 of Lord Justice Auld's judgment at 291 and 292. And 17 is that the rule applies to any, whatever the nature of the claim. Pausing there, that part of the statement hasn't been disturbed by Singh, hasn't been disturbed by Daniels. They were looking at the anything done aspect of the statement by Lord Justice Auld and Heath. And then we get at paragraph 19 the issue around whether there's anything in the 1975 Act that disapplies the immunity. And at paragraphs 51 to 52, we get Lord Justice Auld's treatment of that issue. So on page 301 to 302. So Mr. Hand, who was for the Commissioner, submitted at 348H, there was no basis upon which special provision could be made to exclude claims for unlawful discrimination, however important they become. And then Lord Justice Auld at 52, I have no hesitation in agreeing with Mr. Hand's stance. So the proposition...
I would have thought, this is apparently as recent as 2004, but I would have thought that any barrister nowadays who asked a complainant to demonstrate her breast being groped would be on a charge before the BSB before his feet touched the floor.
Yeah.
Do you say he would be able to say that he's immune from that?
Well, that would be professional conduct proceedings. That would be. I'm not sure that that's in the nature of a claim. What we do know is excluded is a complaint in the Employment Tribunal for sex discrimination on those matters.
What we've got is certainly a claim that a case that you drew our attention to that shows that proceedings before what was then the Inns of Court body was indeed equivalent to judicial proceedings and subject to the same immunities.
Yes.
So,
Yes. Well, the council might rely on that in its defence, in their defence before the Bar Standards Board. But be it as that may, the proposition in Heath that the immunity applies to whatever the nature of the claim, not just claims for defamation, is there undisturbed by Singh.
subject to all and Simons, of course, because you can claim negligence.
My lady, yes. But can I move on to Lake, please, which is at tab 15? And so Lake was a claim for protected disclosure dismissal under section 103A of the Employment Rights Act. But it's important to note that in Lake, under the police conduct regulations that were then in force, the Chief Constable had the power to review the conduct board's decision. So you had a decision by the board, but then a power to review by the Chief Constable as to whether or not to uphold the decision. And as the Court of Appeal in P made clear, that Lake is really a narrow proposition that the Chief Constable is the effective dismissing officer and is not bound by the findings of the board. But Heath was before the Court of Appeal in Lake, and we can see references throughout the Lord Justice Peel's decision in Lake to that, paragraph 11, for example, where he sets out the tribunal's decision. There's reference to Heath. But importantly, at paragraph 27 on page 327, it's stated there, the customary immunity which judges, advocates and witnesses enjoy, as confirmed in Heath, is not challenged in the appeal, so that impeachment in that sense does not arise. So there's nothing in Lake that says, well, Lord Justice Ald was wrong in Heath to say that the immunity applies to any type of claim, subject to the exceptions. We also have at paragraph 25 a concession made there that the challenge to the actions of the Chief Constable in confirming the decision to dismiss could proceed to a full hearing. So when we get to paragraph 30, the proper reading of paragraph 30D, the challenge is that they reached the wrong decision. It is the challenge is to whether the reason or the principal reason of the Chief Constable as the dismissing agent was the alleged protected disclosures. So, in other words, the ratio of Lake is a narrow one, that the Chief Constable is a dismissing agent. There isn't anything there that overturns or doesn't follow. Overturn isn't the right phrase, but doesn't follow any aspects of Heath or provides any inroads into that part of Lord Justice Ald's decision in Heath. And then to complete the circle, we get P in the Court of Appeal, and that's in tab 20. And at page 423 of the authorities, paragraph 20, he rejects an attempt to neutralise the authority of Heath by deploying the latest decision in Laing. And then it goes on to say, it is plain that the court in Lake proceeded on the premise that Heath was correctly decided. More important is the fact that there is anyway no arguable inconsistency between the two cases, given the extremely limited scope of the decision in Lake. And we get there in that last sentence, the expression of the ratio in Lake. we get at paragraph 21 treatment of Singh. I do not need to take time with it. At paragraph 34 of my Lord Lewison LJ refers to Heath, its correctness is not questioned. So we submit that far from this case being on all fours with Lake, which is what my learned friend, his case is, it provides no support for his submission, that in fact its proposition is extremely narrow indeed and fact specific to that the particular regulations that were in force at the time that provided the Chief Constable with the power of review. And there's nothing in this trio of authorities that says that what Lord Justice Ord said was wrong, that the immunity applies to any type of claim, including sex discrimination claims. But we submit as a fortiori, it applies to protected disclosure claims under the Employment Rights Act. So, my lords, those are our submissions on the law. If I can move on to an analysis of the pleaded case in the next, so we can leave the authorities bundle and put that aside and go and find the core bundle in tab 10, and we get the claimant's Employment Tribunal claim statement at 155. And Mr. Rogerson was in person when he drafted this document, but if we have a look at 16G at 160.
I'm sorry, Mr. Kemp, can I just interrupt? Is this a document that was appended to the ET1?
Yes, my understanding is that it was, that this would be, yes, my understanding is that this is the grounds of complaint. He's described it as the Employment Tribunal claim statement, but that it was appended to the claim form, which appears at 143.
Thank you.
And so we're on G, just on the first sentence there, on the 21st of July 2021, the first respondent commenced arbitration proceedings against the claimant. So there are 3 points that arise from that. The complaint is not about some prior decision on X or Y date to bring the arbitration. It is squarely about the commencement of the arbitration proceedings. And you have our submissions I made earlier, which is that the commencement of the arbitration is the submission of the request for arbitration to the Secretariat. So it's inextricable from the arbitration's initiating documents is our submission. But we also submit that paragraph 16G can't be read in isolation, because his case as to detriment doesn't just stop at the end of that first sentence, it goes on. And the following sentences provide particulars of detriment that he's complaining about. One is an extremely costly process, which we see in the second sentence. And then we see in the second paragraph that what Mr. Rogerson is saying there, where he says, additionally, in the arbitration claim, the respondent accuses, and then he goes on in the second sentence, say, in reality, ... are accusations in the arbitration claim that do not reflect reality. In other words, the basis of the claim, arbitration claim, is groundless. It's not rooted in reality. This is what he is complaining about in this paragraph. And then we have at the bottom of the page a point about the arbitration forming part of a pattern of use of strategic litigation to prevent disclosures of information in relation to their harmful behaviour. So this detriment has to be read in the round, not just with the first sentence in isolation. That when one does that, we submit that the crux is that the claimant was forced to defend abusive or groundless arbitration proceedings. That's the essence of this paragraph reduced down through the particulars. And it's important to note that there was a list of issues before the Employment Tribunal, but it referred in brackets to 16G. In other words, the way in which the detriment was expressed in the list of issues before the tribunal wasn't just confined to the commencement of the arbitration proceedings and no more, but expressly referred to explicitly 16G. And there was never any abandonment before the ET or the EAT of any other sentences of 16G beyond that first sentence, that the full case on 16G, as I understand it, had always been maintained before the tribunal and the Employment Appeals Tribunal, and that when one takes a step back and looks at what is this complaint really about, it is not simpliciter, the commencement of the arbitration. It is that this was being forced to defend abusive or groundless arbitration proceedings. You might not see the word abusive or groundless, but that is a legitimate inference to be drawn from the substance of what Mr. Rogerson is complaining about.
There are basically two complaints. G complains about the initiation of the arbitration proceedings and how expensive it all is. And the next subparagraph, additionally, a further point is made. But if the first point's good, why does the second point detract from it?
But my lady, we just don't read the claimant's case in that way. The way in which the claimant was advancing his case was to rely on 16G in its entirety. That was the detriment, how the detriment was expressed in the list of issues, because it referred to 16G in brackets. That wasn't abandoned before the ET, and it wasn't abandoned before the EAT. And that what one has to do when faced...
All right, you've made all those points, but Mr. Campbell, what's your answer to my question? If the first point that's made in paragraph G is a good point, how does the second point detract or nullify?
Well, we say that it just isn't two complaints of two separate detriments. It's a complaint about one thing, but the consequential sentences are particulars of detrimental treatment. And so it's wrong to just slice and dice 16G and remove all of the other sections after the first sentence. That's not the claimant's case on detriment. The claimant's case on detriment is reliance on 16G as a whole in the round with its full particulars of detriment. And we say that one also has to look at the pleading as a whole when considering whether or not the core immunity applies. And when one looks at the prayer at 36A on page 165, we see there that what he's seeking to recover in the Employment Tribunal are costs incurred in defending the retaliatory arbitration proceedings, if not recovered elsewhere. So in other words, a full frontal collateral attack, second bite of the cherry on the arbitral award.
That's not an bite on that's not an attack on the arbitral award at all.
Well, it's saying if not recovered.
It's saying we'll recover. I can recover the costs if I lose and I'm made to pay the costs. It's only because you brought proceedings against me that you shouldn't have brought. That's not an attack on the award at all.
Well, my reading of, and it's not a model of draft. No criticism of Mr. Rogerson. He was acting in person. It's not a model of drafting, but it suggests that if he doesn't recover his full costs in the arbitration, he can recover them in the Employment Tribunal. That is a second bite on the arbitration's decision on costs in my submission.
Sorry, it's not. It's just not. It's apples and pears. It's got nothing to do with having a second bite of the cherry. It's not trying to invite the court to revisit anything that's been decided by the arbitral tribunal. It's saying, I respect what the arbitral tribunal has done if it awards costs against me, but I want to be indemnified against that expenditure. That is not a second bite of the cherry.
Well, my lady, there may well be a difference in approach to that, but we submit that in any event, it would require the Employment Tribunal, in order to adjudicate that, to review the documents produced in the arbitration in order to decide what the scope of the arbitration was, what costs were incurred, what the arbitration involved. And we say that all of that impermissibly trespasses on the arbitration and the arbitration documents in our submission.
Can I ask you one other question, please, which relates, let's suppose you're right, and you've got to look at the complaint and the whole, and the substance of the complaint is these proceedings that were brought against me were malicious, groundless, and totally false. Why is there not an analogy with the carve-out from immunity for abusive process of the court by bringing malicious prosecution or the equivalent, which is now recognised in civil proceedings?
Because those cases are distinguishable, because abusive process inheres in the cause of action, whereas it does not inhere in the cause of action for whistleblowing detriment.
Well, it might do if the detriment that's alleged is the bringing of proceedings.
Seems to me you're trying to have your cake and eat it. First of all, you're saying that malice is part and parcel of the claim. Now you're saying malice isn't part and parcel of the claim.
No, we accept that malice isn't a relevant consideration for the ET. The case law is absolutely clear on that. One is looking at motivation, the reason why, the reason for bringing the claim. But there is a point that the proper characterisation of this complaint at 16G is not just commencement of arbitration proceedings simpliciter. It is, however, whichever label you put on it, it is an arbitration that's costly, an arbitration where those allegations don't reflect reality.
And I'm putting to you that if that's right, let's suppose that that is the right characterisation of what the complaint is. Why is that not analogous to a complaint founded on an allegation, so-and-so sued me and there was no basis for them suing me? Now that you can make that complaint in a civil case. You can bring a claim for malicious prosecution in both crime and civil.
We submit that it doesn't inhere in the cause of action, and the closer analogy is with discrimination claims. See Heath and the authorities that follow on that.
Sorry, I'm being very, very slow. What do you mean by it does not inhere? I do not understand.
So in the malicious prosecution, a malicious arrest, all of those cases, a crucial ingredient of the tort is an abusive process. Whereas here, a crucial ingredient of the cause of action of whistleblowing detriment is not an abusive process. We all know what the ingredients of the cause of action are, but abusive process is not one of them. And so this is a case that's much more closely analogous to a discrimination claim, where again, abusive process doesn't inhere in the cause of action of sex discrimination. One point which I do need to cover is the point that's covered by the respondent's notice. We put in a respondent's notice in this case, which has been served, and it is this, that whichever way you cast detriment 3, the claimant's pleaded case for detriment would involve scrutiny by the ET of the arbitration's initiating documents and other statements of case and so on, because the issue before the tribunal will also include not just detriment, but causation of detriment, whether or not the disclosures were on the grounds of the protected disclosure. And my learned friend, in both his skeleton arguments, has repeatedly submitted that the respondent does not dispute the fact that the disclosures influence them to bring the arbitration. That rests, unfortunately, on a mischaracterisation of the respondent's pleaded case.
I'm so sorry to interrupt, Mr. Kemp, but how does the question whether or not the proceedings were initiated on the ground that a protected disclosure was made bear any relationship to the documents in the arbitration?
Well, can I take you to the amended grounds of resistance, where the case on the manner of is put in relation to this detriment. So it's paragraph 29 in page 136 of the core bundle. And sorry, page 135, the paragraph 27, we see here that despite the outcome of the police investigation, the claimant persisted in his campaign of making repetitive and multiple allegations against Mr. Erhard to senior executives at Landmark. And it says the communications contained multiple and repetitive allegations. These communications were also in breach of the claimant's confidentiality obligations in the contract. We get the cease and desist letter, which is a prior detriment, but turning to the detriment in issue, paragraph 29 says, despite the cease and desist letter, the claimant continued to persist in waging his campaign of raising multiple and repetitive allegations against Mr. Erhard to senior executives at Landmark. And my lady, Justice Laing, will be familiar with the decision of the court in Kong and Gulf International Bank, that it will be a question of fact for the ET to decide whether this conduct alleged is properly separable from the facts of the disclosures. So whether the manner of making the disclosures and multiple and repetitive allegations, waging of a campaign, persisting despite the outcome of the police investigation, to the senior executives of Landmark, is the reason that can be properly separated from the disclosures themselves, is a factual inquiry that will require careful evaluation by the tribunal.
Well, sorry, that's not relevant to the question I asked, I don't think,
No.
unless I'm misunderstanding things completely. The point in con is that if you make an absolute pain of yourself in the way that you make your protected disclosures, that may be relevant to the reason whether the treatment was on the ground of the protected disclosure. But what's that got to do with initiating an arbitration?
Well, we submit that the initiating documents of the arbitration will need to be seen by the tribunal in order for the respondent to be able to defend itself on liability at the full merits hearing, because the contemporaneous documentation that will say what the reason for commencing the arbitration was will be the request for arbitration and the statements of case.
Well,
and so
it will be a matter for evidence. So whoever initiated the proceedings will have to put in the statement and say, the reason I initiated the arbitration was because he was making an absolute nuisance of himself. And he'll be the witness will be cross-examined by that, and the ET will make its finding of fact. I just don't understand how this point.
He doesn't need to
advances
raise. He
your
doesn't
argument.
need to refer to the terms of the initiating document at all.
we submit, on the contrary, that would be the strongest contemporaneous documentation as to the respondent's motivations at that time. Remember, we're not here looking at some prior act of the decision to bring the arbitration, but squarely the commencement of the arbitration itself. What commenced the arbitration? The request for arbitration. What contains the complaint that was the subject matter of the arbitration, the statements of case. All of those documents would be relevant for an ET to scrutinise fairly the decision as to the reason why the arbitration proceedings were commenced. It would be wrong to treat the issue purely in a vacuum, where you just got witness evidence only. The respondent would be deprived of being able to place the documents before the court in order to defend itself.
Well, if the respondent wants to put those documents in front of the tribunal in order to defend itself, it can do so.
But then-
I still don't
but
understand.
that would
how it's
involve
got
the
anything to do with immunity.
So that would involve the tribunal scrutinising those documents that were the subject matter
Well,
of the
only to
proceedings in
see
the arbitration.
to what extent they support the evidence of the respondent that the reason why the arbitration was commenced was nothing to do with the protected disclosures, but to do with the fact that the claimant was making a nuisance of himself, to put it.
It may not actually take matters much further at all. I mean, thinking about it, suppose you sued him for breach of confidence in these proceedings. I mean, the claim form and the statement of case that would be brought against him would be presumably be reasonably public documents. There wouldn't be the same obligations of confidentiality attaching to it. But the tribunal, if you sought to rely on it, wouldn't be looking to see or second guess anything that was done in the proceedings, or it would simply be looking at them, as my lady says, for the purpose of whether they gave credence to the argument that the motivation behind it was bad behaviour.
Well, my lady, you've seen how we put it in the skeleton argument. You've heard my submissions on it. We submit that a tribunal considering this sometimes quite difficult in practice distinction between the fact of and the manner of the disclosures, would need to traverse the founding documents of the arbitration to scrutinise the motivations that existed at the time that the arbitration was commenced. And so we submit that trespasses on the arbitration in Singapore. So I've given you my submissions, I think, on the ambit of the immunity, its application to claims under the Employment Rights Act. I've given you my submissions on the pleaded case and how you ought to approach it. It now falls to briefly look at the Employment Appeals Tribunal decision before addressing on a couple of other points, and then I'm going to hand over to Mr. Mather, who will make submissions to you on grounds 3 and 4. And ground 1 is that the EAT fundamentally misunderstood the legal test. We submit that there's no substance in that ground because, of course, the specialist EAT judge had in mind the statutory provisions for protected disclosure detriment, but the issue she had to decide on a strikeout application was whether the respondent's plea applied to the detriment that had been alleged. And that's what she did. She looked at the pleaded case and the way in which it was expressed by Mr. Rogerson's advocate, and she applied the law on judicial proceedings immunity to that case. And if we have a look at the EAT judgment in tab 5, paragraph 7,
Page, please.
page 47 of the core bundle. Sets out the claimant's pleaded case in full. Paragraph 8 records Mr. Pollack's confirmation in the hearing that the third detriment is not simply as put to the trouble and expense of having to face the arbitration proceedings, but that the crux of his complaint is that the proceedings were groundless and brought maliciously. Pausing there, that statement wasn't determinative in the reasoning of the Employment Appeals Tribunal's decision, because it also took into account the pleaded case at paragraph 7. But in my submission, it does have probative value. Mr. Rogerson now has the distinct benefit of being represented by counsel. Legitimate question to ask counsel: what is your client's case? What's the gist of the allegation in paragraph 16G? Answer: the gist is the proceedings were groundless and brought maliciously. That's what the detriment that I'm complaining about. And we then get at paragraph 10 referral to the agreed list of issues, which, as I've submitted, cross-refers to 16G in brackets there. And we get then treatment of the case at paragraph 92 of the EAT's decision on page 75. It is important to focus on the nature of the particular claim, the cause of action in question, what the cause of action is founded upon, and the extent to which this relies upon what is said or done in the earlier judicial or quasi-judicial proceedings, as opposed to events outside of the earlier proceedings. That was a correct self-direction in law in my submission. It was a correct application of the approach in Singh.
It's interesting, the formulation is what's said or done in an earlier judicial or quasi-judicial proceeding.
Yes, so yes.
So that statement extends to the document launching the proceedings in your submission.
This isn't, sorry, that does in my submission, but the tribunal, the Employment Appeals Tribunal, didn't look at the issue in that way. It based the issues on the articulation of the construction, proper characterisation of 16G being a groundless and abusive arbitration rather than the commencement of the arbitration per se. Paragraph 95, we see there that the judge identifies not just the way Mr. Pollack put it on behalf of his client, you see paragraph 8 is referred to there in brackets, but also the pleading itself. Paragraph 7, she had in mind the pleading itself at 16G, but also the probative value of how Mr. Rogerson's advocate was describing the gist of the detriment that was being pursued. And then at 97, we get the ET would only be able to decide if the earlier proceedings were groundless and maliciously brought if it ascertained what was said in those earlier proceedings and made an assessment of the documentation that the respondent submitted in initiating and supporting the arbitration. There's no fundamental understanding there in the EAT's approach to the issue. The EAT has approached the issue by extensive reference to the authorities and applied it to the substance of the pleaded case with the gist of the detriment as confirmed by the claimant's counsel. There's no error of law here or application of the statutory provisions under the Employment Rights Act. So we say that ground one has to be dismissed.
Isn't this all a little bit artificial? Because in considering the two detriments which you accept are going to have to be considered by the Employment Tribunal, the Tribunal is going to have to consider whether, on the one hand, Mr. Rogerson is a troublemaker trying to extort money, or on the other hand, his complaints about the way that your clients behave are justified. So, and that's going to, in practice, determine the answer of whether the proceedings were brought maliciously or for good reason.
Yes, but it will involve consideration of the founding documents and supporting documents in the arbitration.
I don't see why
Well,
it
no, it
will.
wouldn't.
Suppose the conclusion is, considering detriments 1 and 2, Mr. Rogerson is a troublemaker trying to extort money. In that case, it's very easy to see that it's fair game for you to try and stop him by arbitration proceedings.
But okay, let's take.
Conversely, if you're the bad boys, it's not a very big leap to think that your badness is continuing through to the commencement of the arbitration proceedings.
But let's look at, for example, the accusations not reflecting reality point. How can the trial tribunal determine that without looking at what the accusations were in the notice of arbitration to see whether or not they reflected reality? The tribunal would have to see those documents in order to reach a conclusion on that particular aspect of the complaint. And so it's in my submission unrealistic to expect a trial tribunal to determine that detriment without reference to any of those founding documents.
Yeah, but my lord's point is that there are 2 detriments which haven't been struck out and about which the tribunal is going to have to make a decision on the facts. And the points are very similar because those 2 detriments were done because of the protected disclosure rather than because of the fact that the respondents thought that the claim was a nuisance. That's pretty much the same factual issue as is involved in the 3rd detriment.
No, it's not, because the third detriment, as characterised correctly by the EAT, is that the arbitration, the gist of the complaint is the arbitration is abusive or groundless. That would involve consideration of the founding documents of the arbitration. The prior detriment, the cease and desist letter, and I forget what detriment 1 is about, would not require analysis of those documents because one is not looking at whether the founding arbitration proceedings are groundless or abusive. So
look at the way you plead it at page 136, paragraph 21. You say, despite the cease and desist letter, the claimant continued to persist in waging his campaign, multiple and repetitive allegations. Respondent eventually took the view that enough was enough and started arbitration. Well, if you make that good, that's one thing. But if the tribunal decides that he was not waging a campaign which was unfounded, then the commencement of arbitration speaks for itself.
My Lord, 29 speaks to a separate
You still
distinct.
need to look at the request for arbitration to form a conclusion about that.
My Lord, paragraph 29 is a separate and distinct issue, which is about the reason why the arbitration was commenced. But the EAT's decision was on the premise that detriment 3 wasn't just confined to the commencement of the arbitration, but the real essence or the gist was a groundless or abusive arbitration. And so when one is considering that issue, let's assume for a moment the EAT was correct in its analysis of the pleaded case. Determination of that pleaded case on whether there was a detriment, as alleged, would require consideration of the founding documents of the arbitration. And so the EAT was right when they reached that conclusion and gave themselves that direction on page 76. If I can just say this briefly, the Employment Tribunal's decision, the Employment Tribunal didn't refer to the pleaded case, 616G, didn't set it out. It didn't record in full the way in which the detriment was put by my learned friend, because the way it was put also included the arbitration not being for a proper reason as part of the detriment. And for the reasons given by the EAT, the analysis on the immunity 51, 53 and 54 was wrong, because the judge there appeared to think he was dealing with if the immunity applied, it would prevent someone from being sued anywhere, rather than the cause of action having to be founded on the thing said or done in the proceedings, which is, I think we can all agree is common ground, is how the immunity applies. So the ET's decision was wrong, 51, 53 and 54.
What's wrong with the ET's reasoning in paragraph 31 of the ET's judgment?
It's an incomplete description of the detriment because it doesn't.
But the ET is it's a piece of legal analysis by the ET, which is the specialist tribunal. The ET is saying you don't need to show what the motive was. Let's just focus on the bringing of the arbitration.
But we don't dispute that legal analysis, that motive or malice is not part of the test. The issue in causation is motivation, the reason why. That the characterisation of the detriment that was put before the tribunal wasn't just that it was a malicious arbitration, it was that the detriment was an arbitration not brought for a proper reason, in other words, a groundless arbitration, which the judge didn't consider in his judgment. And he hasn't set out 16G in full, which was relied in full. There hadn't been any abandonment of that case by Mr. Pollack before the ET.
No, but the ET's made a decision that none of that matters. What matters, as a matter of legal analysis, is the bringing of the arbitration.
Well,
That's all that needs to be established. What's wrong with that analysis?
Well, we submit that the proper analysis is what is the allegation being advanced by the claimant. The allegation of detriment being advanced is not the commencement of arbitration proceedings without more. It is 16G read as a whole and in the round, and the essence is a groundless or abusive arbitration. That's
surely, if your key point is right about the immunity, it doesn't matter whether the allegation is that it's groundless or not.
Of course, yeah, of course, my lady. If you're,
which is why I wonder why we're going around in circles about this. Either, if you are right as a matter of principle, the initiation of proceedings in arbitration or in court, whether malicious or genuine, is totally immune and cannot be relied on as a detriment.
my lady, exactly, that's precisely right. But if you're against us on that, we submit that the 16G properly construed in the round as a whole is an allegation that falls within the scope of the core immunity for the reasons that I've given, and the EAT was correct to so hold for the reasons that it gave. So we have a primary and a secondary case here that's being advanced.
So if it falls outside the scope of the... If we were against you and we decided that the core immunity does not apply to the initiation of arbitral proceedings, how does the fact that the pleaded cases that those proceedings were commenced maliciously, let's say, or groundlessly, help? How does that bring it back in within the core immunity if we decided that as a matter of principle it doesn't apply?
Because part of the allegation would require looking at what was said in the arbitration notice and whether or not those allegations reflected reality, and that would fall foursquare, I think, within the core immunity. And in order to determine that, the Employment Tribunal would have to look at the founding documents of the arbitration to see what the complaints were and whether or not they reflected reality as part and parcel of the complaint for detriment. Can I just finish, before I hand over to Mr. Mather, just a couple of points, but very briefly. Roy and Pryor is not of assistance because the cause of action was a malicious arrest, and therefore abusive process inheres in the cause of action of malicious arrest. It's not the case here with a cause of action for protected disclosure detriments. And so that's our position on Roy and Pryor. Willers and Joyce is of no assistance because what the court was dealing with is whether or not there was a civil right and damages for injury as a result of the malicious prosecution of legal proceedings, and it looked at various policy considerations. XGY at 65I is authority for the proposition that, as we went through this morning, that where one is looking at the application of the core immunity, there's no justificationalism that applies at that stage. So the weighing up of different policy considerations in Willers is of no assistance to you, to the analysis you need to perform. And so, without further ado, I'm going to hand the lectern over to Mr. Mather, who's going to cover ground 3 and ground 4.
Very good. Well, thank you, Mr. Chairman.
My ladies, my lord, I address ground 3 and 4 as Mr. Kemp says, and our central submission on ground 3 is that it is immaterial that the quasi-judicial proceedings here, which in our case attract core immunity, it is immaterial that they were seated in Singapore and that EAT was right to hold so. So, my ladies, my lord, before turning to the structure of my submissions on this ground, I make 2 preliminary points from which the onward submissions proceed. The first is that for the purpose of ground 3, it is presupposed that the detriment in question falls within the core immunity. And that is analytically necessary to isolate the additional issue that arises under this ground, which is whether JPI that would otherwise apply does not apply solely because the tribunal is Singapore seated. And the second preliminary point is this: the Employment Tribunal found that the arbitral body in question was a quasi-judicial body. There has been, I beg your pardon,
That hasn't been appealed.
that has not been appealed, no. So there is no dispute that JPI would apply to the arbitral tribunal if its seat were in England. And my ladies, my lord, I will show you there is no principled reason in our case for the English courts to apply the policy rule of JPI to an English-seated arbitration, but not to apply it to a Singapore-seated arbitration. We say that taking that approach would run up against 2 very important policy considerations. And the first is the very strong pro-arbitration policy of the English courts in seeking to support arbitration. Paragraph 23 of our skeleton, I don't turn it up, but the reference is Core Bundle, page 213, addresses some of those cases which my Lord Justice Males will know well. They're in different contexts, but the propositions there are general ones. And my ladies, my lord, this point is a fortiori here when we're dealing with a final award. And as my Lord Justice Males has noted, where there is a policy interest that has been given domestic effect to via Part 3 of the Arbitration Act, sections 100 onwards, which give effect to the obligations under the New York Convention. Now, the second policy consideration is the principle of comity. These 2 policy considerations intertwine, but they are conceptually distinct. And this, of course, requires harmony with international frameworks, in particular the New York Convention, which has been given domestic effect. My ladies, my lord, I structure my submissions as follows. First, I will consider the relevant authorities to this ground, this issue. And second, I will consider how the tribunals below approach the issue. Third, I will make submissions on why ground 3 should be dismissed. So, turning first to the authorities, the first...
I suppose in practical terms, it is more of a detriment, assuming it's a detriment at all, to have to face arbitral proceedings on the other side of the world than it is to face arbitral proceedings in your home jurisdiction. So I suppose that's a different point.
My lord, yes, but I also do say on that point that this was a Singapore law-governed contract with a Singapore law arbitration agreement because the respondent, and it's the foundation, it's not any individual, the respondent is domiciled in Singapore, and my understanding is that the claimant, at the time of entering into this contractual agreement and beginning his work, was living in New Zealand. So this Singapore-based foundation is actually it's the territorially more proximate one.
I don't think we've seen the workers' contract, but with the arbitration clause in it, but it's a Singapore...
It's Singapore seated, and the applicable law, the proper law is Singapore law.
That's an express term.
That's an express term, my lord, yes. Yes, and my understanding is that that is the reason that a Singapore entity is the entity with which Mr. Rogerson entered into a contract. My lord, starting with the case of Trapp and McKee, and that's at Authorities, tab 10, page 151. and my ladies, my lord, I may give you a few more references for your note than I had intended, given the pressures of time. But just to remind your ladyships, your lordships, this is a case that concerned evidence given at a local inquiry held before a commissioner appointed by the Secretary of State under the Education Scotland Act 1946. And the inquiry was appointed to look into the reasons for the dismissal of a head teacher, Mr. Mackey. Dr. Trapp had brought a claim for what was said to be maliciously false evidence given at the inquiry by Mr. Mackey, and Mr. Mackey claimed absolute privilege and succeeded. The key question before the House of Lords was whether the inquiry in question was capable of attracting absolute privilege. And my ladies, my lord, if you go to authorities page 152, you'll see Lord Diplock's leading judgment begins there. And that's internal page 378, and I don't go into it in detail now, but at 378H to 379F, Lord Diplock discusses various cases, and the key passage for current purposes is 379G, where he says, so to decide whether a tribunal acts in a manner similar to courts of justice, and thus is of such a kind as will attract absolute as distinct from qualified privilege for witnesses when they give testimony before it, one must consider first under what authority the tribunal acts, secondly the nature of the question into which it is its duty to inquire, thirdly the procedure adopted by it in carrying out the inquiry, and fourthly the legal consequences of the conclusion reached by the tribunal as a result of the inquiry. And it goes on. To attract absolute privilege for the testimony of witnesses, the tribunal, by whatever name it is described, must be recognised by law, a phrase first used by the Court of Exchequer in Dawkins. This is a sine qua non. The absolute privilege does not attach to purely domestic tribunals. Although the description recognised by law is not necessarily confined to tribunals constituted or recognised by Act of Parliament, it embraces all that are. It embraces all that are, and so includes the local inquiry in the instant case. So, my ladies and my lord, taking a step back, there are 2 points I make about what we have just seen. And the first is that there is no mention here of any further requirement beyond those stated, such as the body needing to be located here. But what has particular resonance in my submission is what we have just seen. It embraces all that are. So if an Act of Parliament recognises a tribunal, that is a qualitative bedrock. It is an imprimatur of legitimacy. And there is no dispute before you, my ladies, my lord, that that would include a domestic seated arbitral tribunal pursuant to the Arbitration Act. But equally, and again, this is my Lord Justice Mayall's point, that Act recognises foreign seated tribunals. Hence, not only the powers in Section 100 onwards to do with the recognition and enforcement of New York Convention awards, but also the powers under Section 2.2 and Section 2.3, which ladyships and your lordship will be very familiar with, to do with the English court's ability to make orders in support of that foreign-seated arbitration. My ladies, my lord, there is one further reference from Trapp. I don't turn it up, but it's Lord Fraser's speech at 388B, internal 388B, which is authorities page 12. He makes essentially the same point. He's supporting what Lord Diplock says. From here, my ladies, my lord, can I please go to the authority of Hasselblad, and that's authorities tab 11, page 164. Now, my learned friend referred to it when considering Mr. Justice Foxton's discussion of this case, and he does, and Mr. Justice Foxton, as we'll come on to see, takes a different view of it from Ms. Justice Heather Williams. But what was the case about? It concerned a complaint made by a company to the Commission of the EEC that the plaintiff, who distributed Swedish-made cameras in the UK, was carrying on business in breach of Article 85 of the EEC Treaty. The Commission commenced proceedings to investigate, and during those proceedings, the company sent a letter to the Commission, signed by the defendant, making allegations against the plaintiff's business. The plaintiff brought a defamation action against the defendant for the letter he'd signed. And at first instance, I don't turn it up, this is authorities page 167, internal page 478A. Mr. Justice Coleman found that the EEC was a quasi-judicial body and the plaintiffs appealed on that ground. You'll see I have that at 478D. And at 478F, we see a bench memorandum was provided because the judge had been asked to dispense with formal judgment. In terms of the contents of that memo, at 478G, the judge took the view that the Commission was in its judicial / quasi-judicial role a court, which was in effect one of ours. And over the page at 479C, which is authorities page 168, and this is the Roman G that you will find in the text. He says, where a citizen of ours produced a document to a body we recognised, supported, and whose orders we enforced, it would be contrary to good sense and justice to expose him to an action for libel on the documents here. Indeed, on his view, it was playing with the judge's view, it was playing with words to discuss the judicial or quasi-judicial nature of the Commission's role here. It was a court and a court of ours. So what the judge is saying are two things. First, that this body, the Commission, has a judicial or quasi-judicial role. And second, it is also one of ours. It's one of our bodies, and that's an additional point. And so, my ladies, my lord, that was squarely within issue in this appeal. And the majority judgment given by Sir John Donaldson begins at authorities page 179. That was the Master of the Rolls. And Lord Justice O'Connor agrees with the Master of the Rolls, and that's at authorities page 193, internal page 504G. And at authorities page 180, this is the top of internal 491A, he goes to the trap criteria and he considers those. And then if I can take you down, please, to 496H, which is authorities page 185. We see at the very bottom of the page, what he says is this. This procedure, and he's talking about the procedure of the Commission, is wholly dissimilar to that of any court or judicial tribunal operating under the common law system. But I do not think that that is the test. When in Trapp and McKee, Lord Diplock referred to a tribunal acting in a manner similar to courts of justice, and Lord Fraser of Tullibelton to tribunals having similar attributes to courts of justice, I think they must have had a wider concept in mind, which would embrace courts of justice operating both under common law and under civil law procedures. Skipping ahead slightly, he then goes on to say, however, the fact that the decision is reached by commissioners who have not attended the hearing on the basis of advice from representatives of the European Community nations who are not directly concerned, seems to me to show that the Commission is acting in a manner which is dissimilar to that of either civil or common law courts of justice, and that its attributes are dissimilar to such courts, This is not a criticism of the Commission, it is merely an acceptance that the Commission and its procedures fall into a different category, better labelled as administrative. So, my ladies, my lords, the issue that required determination by the court in Hasselblad was whether the Commission was acting in a manner similar to courts of justice. And the court answered that no. And why? It did so because the Commission acts neither like common law courts nor civil law courts. Its attributes are dissimilar to such courts. Now, in turn, the essential premise there is that the touchstone by which absolute privilege applies is not merely a common law court, it's also a civil law court. So the reasoning presupposes that a civil law court is capable of attracting absolute privilege. Because if the Commission had acted like such a court, as well as a common law court, it might have as well. So because it is applying this premise that leads to that conclusion, in our submission, this is clearly a primary holding by the court. And my ladies, my lord, you can also see that from the head note, which is at page 475, authorities page 164.
That really be right, because the issue was whether the Commission was a judicial or quasi-judicial. What stage of the civil law court was a right one put in?
My lady.
And anyway, the Commission at that time, if it was a judicial or quasi-judicial body, was part of our system of the administration of justice.
My lord, yes. Dealing first with my lady Justice Lang's question, yes, that was the issue that required determination. Is it judicial or quasi-judicial, or is it administrative? But an essential premise in the reasoning to show that it was administrative rather than judicial or quasi-judicial was that it didn't act in a manner similar to civil law courts or common law courts. So that is why civil law courts, in my submission, the presupposition is that they would be capable of attracting absolute privilege. That the
Capable of or did?
well, that they
They didn't need to decide. Yeah, I'm just not finding this helpful. I mean, there must be authority that says, that tells us whether or not this rule applies to civil law courts.
Why does it matter?
Yeah.
Why does it matter at all to anything that we have to decide? I mean, you've got a finding that an arbitral tribunal is a quasi-judicial body. Speaking for myself, I wouldn't find that a terribly difficult finding to uphold. Therefore, subject to where it's seated, it's subject to the same rules as any other quasi-judicial or judicial body. You don't need to delve into whether civil courts are covered because we're not dealing with civil courts.
My lady, yes, I agree. The reason that I address it is because it is a point that's taken to show that there is authority of this court, showing that there is no territorial issue that arises, but it's only one point. Now, the two further bases that we say that it's immaterial, that the arbitration here is foreign seated, relate to the arbitration, the pro-arbitration policy of the English courts, as well as the point on comity, and those are further matters that I intend to address. I'm addressing this now, my lady, because Hasselblad is one of the points in issue between the parties. I am very conscious of the time, my lords, my ladies. If I could briefly turn up the case of Commercial Bank of
I
Dubai.
think we were told at the beginning of the day that the agreement was that your side would finish at 3:40, which is now, and I think Mr. Polak kept within his time, so we won't stop you now, but you do need to wrap it up quite promptly.
I'm grateful. I will just make one further point, and I won't address ground 4, ladies, my lord, because Lord Justice Mills, what you said earlier is true. Either we're within the core immunity and it doesn't take Mr. Pollack any further, or we're not, which is not the basis on which our claim is put. But just turning up Commercial Bank of Dubai, and that starts at page 769, but could I please take you directly to paragraph 116, which is at page 804. And this was touched upon by my learned friend. And this is the passage that in my submission you will find assistance from as to some of the rationales why the pro-arbitration policy of the English courts tells against a distinction between foreign and domestic seated arbitrations. This is authorities page 804. And paragraph 116, there's a discussion about the American case of Rollin and witness immunity in arbitrations. Paragraphs 117 to 119 are key in my submission. You'll see Mr. Justice Foxton, as he then was, talk about the very strong public policy in favour of the finality of arbitration awards. We are here dealing with a final award, and the English courts being astute to prevent collateral attacks. There's a reference to the New York Convention. And then at paragraph 118, he talks about it may be that a qualified form of JPI applies, and he refers to the case of Westacre. And Westacre basically says that foreign arbitral awards are better categorized with domestic arbitral awards rather than with foreign judgments. And that's because of the parties' agreement to enter into arbitration. And at 119, he says it is possible to justify the application of JPI on the same basis. And very finally, my ladies, my lords, there was a reference to the issue of comity, the modified rule versus the bright line rule, and my lady Justice Andrews said this entirely correctly. It doesn't need to be decided here, because on either approach, even with the modified rule, the presumption of similarity applies because we're dealing with a Singapore-seated arbitration. So unless I can assist your ladyships and lordships further, I will hand over now to my learned friend.
We're very grateful. Thank you very much, Mr. Mitchell. Yes, Mr. Polak, what do you want to say?
Thank you, my lord. I will keep it particularly brief. There's a couple of things I just wish to come back on in relation to what my learned friend Francis said in relation to interpretation of the detriment. We say it's clearly, the crux of it is clearly based on the initiation of arbitration. He says that it's necessary for us to rely on matters within the arbitration to determine that. We say that's not right. We do not rely on the arbitrator's finding of physical and verbal abuse by Mr. Werner Erhard. We will prove it independently through recordings, witness statements, and the normal type of evidence that our employment tribunals hear every day. So we say that is simply not a requirement. If the respondent wishes to rely on anything, we don't see how they could, given what's included within, to say that they didn't bring arbitration because of the predicted disclosures, then they may wish to make that type of application. To make those points to start with, my learned friend just now said that the reason for the contract being a Singapore contract was because Singapore is somehow closer to New Zealand. Mr. Rogerson signed the contract in this jurisdiction, and the other contracts of staff members were in places like the British Virgin Islands and around the world. So the aim of the contracts was seek to get away from English employment rights, which was obviously not successful. My learned friend just recently pointed to Commercial Bank of Dubai and paragraph 116. Paragraph 117, it may be relevant, I'll leave it with your ladyship, your lordship. It talks about qualified privilege for arbitrators, which is different from judges in our domestic system. So if there's some difference, should there be a non-qualified, directly applicable privilege for parties in an overseas arbitration when even the arbitrator isn't given that? Would that be correct?
Well, that's because of Section 29 of the Arbitration Act.
My lady, yes, but it would seem odd that for this court to recognise, especially in the context of the beginning of an arbitration, the difference between something started in this jurisdiction, something started overseas, is our courts have no control over how it's done. I think that's the main point I would make in relation to whether initiation overseas. And it's not just, one can imagine the case in many jurisdictions around the world, it's done in response to whistleblowing when multiple claims are brought. Is our law really to say that that can take place? A whistleblower can have 10 or 15 cases brought in the same or different jurisdictions, and we say that can't be right. In relation to, you know what we say about the detriment drafted by a lay person, but the crux of what we say is the initiation. We say the case law does not include that as the core immunity. If it ever did, it does not currently, because to do so would not fit within how it's described in Sing. The example I gave earlier in regards to paragraph 65, which I'll just refer you to again briefly.
Paragraph 65 is soon.
It's the example where it's stated that damages can be given for a initiation of an English case in breach of a arbitration agreement. I might be, it's at Authorities Bundle, page 394. It is paragraph 65.
I don't think that was challenged, was it?
No. And we say that it cannot be an absolute privilege, and that for that to apply in relation to the starting of cases. My learned friend, Mr. Kemp, King's Counsel, referred to things said or done in court. We don't characterise the decision to initiate arbitration as something done in court. I've addressed your lordship, your ladyships in relation to there not being an arbitrator yet at the point of initiation, but we say it falls outside of that language, which is repeatedly used throughout the case law. In relation to Heath, my learned friend Mr. Kemp makes claims about that. That's a direct attack, as I said before, upon the proceedings within the disciplinary tribunal. Your ladyship spoke about the selection of the tribunal. Of course, that's one part of it, but the main nub of that claim was the actions within. I take your lordship's point that the decision today may be a very different decision in relation to asking for demonstration of the sexual assault of the witness in court. But even just looking at the principles of that case, that's very much concerned with what happens within an actual hearing or proceedings, rather than things which happen outside them or the initiation of them. You have my point in relation to Laing. We say provide some support, but the initiation can be a detriment. I don't know, my lord, if there's anything you wish me to directly address.
No, if you've said, if you've made the points that you want to make, then I think we're.
If I may have just one
Content.
moment. Thank you. My only thing I left for me to say is in relation to the arguments about separability on the authority of COM. We say that that's clearly a matter for the jurisdiction of the Employment Tribunal to determine, and not for your lordship, not for your ladyship. Thank you very much.
What is the matter for them?
In relation to what my learned friend says about having to view the arbitration documents, we simply make the point that questions of what evidence can be called and can't be called can be dealt with in the tribunal properly there. Well, those are my points. Thank you.
Well, thank you very much. We will reserve our judgments. They will be provided to you in draft when they're ready. That will be on basis that they are for the limited purposes of enabling any corrections to be identified, corrections of a minor or typographical nature, and to enable you to agree an order. If you're able to agree an order, no matter whatever you decide, so much the better. If you can't, we will have short submissions in writing. We usually allow only a short time between provision in draft and formal hand down. If you find you need a little bit more time to agree something, then by all means ask.
Thank you.
Otherwise, we're grateful to you all for an interesting argument, and to those who've supported you. And you're appearing pro bono.
I am, my lord.
And that's particularly commendable on your part. So we're grateful to you. That concludes the hearing. Thank you very much.
All rise, approval.